When somebody is arraigned in Massachusetts, that's when they're first in front of the judge. The announcement of charges will be read in open court. Your name will be announced. So, for instance, Mr. Smith, you are charged with assault and battery. How do you plead? In district court, you don't even have to say guilty or not guilty. If you're in superior court, you have to answer the clerk and say not guilty. In some cases, a prosecutor may ask for bail. In those cases, the prosecutor will ask for a specific amount of money that you have to pay in order to be released. They will outline a reasoning for their recommendation, and then I have a chance to rebut that, to ask for you to be released either on personal recognizance, which means you don't have to put up a bail, or a more reasonable bail that your family can pay. In certain cases where a client is charged with a violent crime, the prosecutor may seek a dangerousness hearing, otherwise known as a 58A. That means that you are held for 120 days without the possibility of getting released. Usually those are not held on the same day. That may be held a few days later. The prosecutor can call witnesses and present evidence. We can also do the same. At the end of the hearing, a judge can either hold the person without bail, release them on a bail, or release them with conditions of release, such as a GPS, home confinement, or certain hours that you have to be home. Another thing that comes up at arraignment is that a prosecutor may ask for you to stay away from a specific area. If a crime occurred at a store, for instance, you may be ordered to stay away from that store. If you were committing a crime allegedly with somebody else, you may have to stay away from that person. Sometimes in a domestic violence situation, the prosecutor may ask for you to stay away from your own home or your own family. So your lawyer really should be prepared for any circumstance, because if that happens, you're going to be out of your house for months and months. A good lawyer will get to know you a little bit before the arraignment, ask about your background, family life, employment. Find out who you are so that way they'll be ready to make a good argument. I can't tell you how many times I've seen defense attorneys in court saying, "Judge, my client's 30 years old. They tell me they're from Lynn. They tell me that they graduated from Lynn English High School. They tell me that they are married," blah, 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 droning on and on. Look, you got to have a lawyer who's excited to be there, who really wants to win and get you out of jail. It's a big deal, so you really have to have somebody who's going to give it enough time, spend time with you, getting to know you well enough to make a good argument, to convince a judge why should they let you out. No judge wants to be on the front page of the newspaper for letting somebody out. So you really got to be compelling and explain to a judge why the only right answer is to release you from jail.